My name is Harry Zavos. I'm a resident of Glendale. And Mayor, this morning you all met, and you met to discuss raising water rates in order to acquire revenue, necessary revenue, to fund necessary capital improvements. At that meeting, Councilman Manoukian suggested an alternate source of funding. He suggested that the charter-authorized transfer of water revenues to the general fund in violation of Article 13D of the Constitution be returned back to the utility to be used to fund those capital improvements, and thus reducing the amount of necessary rate increase or eliminating its need entirely. The city attorney indicated that there is no case on all fours holding that those transfers were illegal, although he did opine that if such a case should be before a court, the court probably would find them illegal. Now, that statement, whether intended or not, leaves the impression that there's a little bit of wiggle room, that there might be some reasonable doubt as to whether those transfers are illegal. And I am of the firm conviction that there is no reasonable doubt, and I believe that that conviction is well supported, even though there may not be a case on all fours. That conviction is based on 4 propositions. The first comes from the Constitution, Article 13D, which states, and I quote, "The provisions of this article shall apply to all assessments, fees, charges, whatever imposed pursuant to state statute or local governmental charter authority." Article 13D makes it clear that it applies to charter cities. And there's a long line of cases indicating that if there is a conflict between the charter and the Constitution, the charter has to give way to the Constitution, and that's only logical. Charter and charter cities are creatures of the Constitution. They only exist because the Constitution provides for them. That's the first proposition. The second proposition is that in 2006, the California Supreme Court determined that fees for water service were covered by Article 13D of the Constitution. The 2 other propositions come from restrictions in Article 13D of the Constitution. Second proposition, I quote from Article 13D. "Revenues derived from the fee or charge shall not be used for any purpose other than that for which the fee or charge was imposed." Fees and charges imposed on water rate payers are imposed to provide them water service, not to be used to support general fund obligations. The fourth proposition, which I read from Article 13D, is almost a restatement of the third proposition. No fee or charge may be imposed for general governmental services. Unless and until somebody produces credible legal authority or argument to undermine these 4 propositions, there is no reasonable doubt that those transfers are illegal. Mr. Manoukian, I want to publicly salute you for you to suggest that fees wrongfully taken from the ratepayer's utility and transferred to the general fund should be returned to that utility to be used to fund needed capital improvements, and thereby reduce the burden on ratepayers to pay for that is simply fair, just, and equitable. It's the right thing to do.
Thank you.